Oh,
Yes, thank you. As Matt said, I'm Kathy Robinson, and I'm a benefits advisor with the Employee Benefits Security Administration with the U.S. Department of Labor, and I've been there about 12 years. And as a benefits advisor, we have two main functions. One function is that we do outreach presentations such as this, where we educate the public or fiduciaries and service providers. I'll talk a little bit more about that later, but with regards to ERISA and the laws related to ERISA. And today we'll talk about the basics of EBSA, which stands for Employee Benefit Security Administration, and ERISA law, and ERISA stands for Employee Retirement Income Security Act. The other thing that we do besides outreach, which I'll mention that outreach is my very favorite part of my job, doing events such as this, teaching either employees or labor union members about their rights as participants in employee or union sponsored plans, or teaching fiduciaries and plan sponsors and service providers, etc., with regards to how to be in compliance with the various laws that are under ERISA or that ERISA is an umbrella over. But the other part of my job, which is also enjoyable, is that we answer a toll-free line Monday through Friday between 8 and 4:15. And I'm pretty proud of the fact that we have 10 benefits advisors, and I'll talk a little bit more about the different jurisdictions in a little while, but we have 10 benefits advisors that basically serve 11 states. And not only, the vast majority of the time, you can get a benefits advisor on the phone within a minute or two, unless we just happen to be particularly busy or perhaps are in training or a meeting or something like that. But like I said, the vast majority of the time, you can get us on the phone right away. So with regards to those phone calls, we educate the public, fiduciaries, et cetera, with regards to rights and compliance under the law, let them know about the publications we have available, et cetera, talk them through certain issues for the most part. And occasionally a participant in a plan will bring an issue to our attention that we are able to assist with, such as they didn't receive a COBRA notice timely, or they're not allowed enrollment on a group health plan and they should have been, et cetera. So we also do informal dispute resolution. And I'll talk a little bit about that more in a little while. Prior to working for the Department of Labor, I was a senior mediator with the city of Kansas City, Missouri. I was the director of mediation at UMKC, and I was the executive director of the Western Missouri Coalition to Abolish the Death Penalty. My very first job, I was an AmeriCorps attorney, mediator, trainer in conflict resolution at Legal Aid. And that was 25 years ago when I became an attorney, and I've been a mediator for 24 years. I have 2 bachelor's degrees, one in psychology, one in sociology, and in addition to my JD from UMKC, I also have a Master of Arts in Conflict Resolution from Antioch University. And it is my pleasure to talk to you today about the basics of EBSA and ERISA law. I want to give you my contact information. It's Kathy with a K, Robinson, as you can see on that first slide. And my phone number is 816-285-1874. And you're welcome to call me. You might call the toll-free line. Information about that is on the very last slide about how to do that. But you're always welcome to give me a call, with the caveat that I do a lot of webinars and have lots of things going on. So sometimes it may take me a day or two to get back to you, but I always get back to people as soon as I can. But I do ask, when you leave me a message, always leave me your phone number. And if you could let me know how it is that you know me. Sometimes people leave me messages and I don't know what they're talking about, and they assume that I know what they're talking about. So if you would let me know how you know me and a little bit about what you'd like me to call you about, I would appreciate it. So again, 816-285-1874. One of the things that I'm going to request that you do is, we're supposed to go to about 1 o'clock today, and then we'll have time for questions and answers. I'll try to be done right around 1 o'clock or maybe just a little bit before that if I can. And if you could save your questions to the end, I would appreciate that. And also on the chat box, if you would use that if there's only some kind of a technical difficulty that needs to be brought to our attention, such as you can't hear me or something like that. And then at the end, feel free to use the chat box. In other words, I won't be checking it while I'm looking at slides and talking to you. I can multitask in a lot of ways, but juggling all of that at once, I'm not so great at. The other thing is that we like to do these kinds of presentations. We like to make sure people are aware of compliance assistance information and requirements, and like to set up as many of these presentations as possible. We cannot do it for a for-profit entity, but we can do it for union organizations, nonprofits, etc. So if you're a member of a group that would like to have me or one of my colleagues come out and speak to you about maybe more specific issues than what we're going to talk about today, such as fiduciary duties for group health plans or retirement plans or COBRA, we have a panoply of presentations that we have available, and I'd be happy to talk to you about that at any time. So please feel free to call me or pass my information on to someone representing a group that you're affiliated with, and I'd be happy to talk to them about that possibility. The other thing that I wanted to say is with regards to this audience, it's difficult to gauge in advance how much you know about ERISA or EBSA. Some of you might have had a great deal of experience with EBSA, usually not necessarily a good sign, unless maybe you were working with benefits advisors, or maybe a great deal of experience and knowledge already about ERISA law. The assumptions that I've made since the premise of the presentation is the basics of EBSA and ERISA law is that you don't necessarily have a lot of knowledge or information coming into it. And so hopefully that's very helpful for people who don't necessarily have a lot of knowledge or experience. Some of you who do, you may already know most of the contents in here, if not all of that. So anyway, I'm delighted to be here, and let's go ahead and get started. Oh, there we go. Okay, so I'm going to talk to you a little bit about the agency I work for with the Department of Labor, the Employee Benefits Security Administration, or EBSA, our mission, who we are, what we do. Our mission statement basically is that we assure the security of the retirement, health, and other workplace-related benefits of America's workers and their families, if it's a private employer or a union-sponsored employee benefit plan. And we try to do this by developing effective regulations, and then doing what the benefits advisors do, such as myself, assisting and educating workers, plan sponsors, fiduciaries, and service providers, and then our enforcement unit or our investigators and auditors vigorously enforce the law. Just real briefly, just so you can see a bird's eye view of our organizational chart, most of that is with regards to what's available at our national office. If you, as a fiduciary or a plan sponsor, ever have a need for an issue that might be helpful with one of the offices at our national office. On the right side, you'll see that it lists the regional offices. I'm in the Kansas City regional office. We serve 10 or 11 states. We're one of 10 offices, like I said. And on the next slide, you can see how there's a breakdown there. We're the one in the middle towards the left on the top. We have the largest geographical region, but due to the sparse nature of the population in our region, we have some of the fewer plans in our region, which is why we cover so many states. But like I said, I'm quite proud of the fact that we cover 11 states and with just 10 benefits advisors in our office, and pretty much answer the phone within a minute or 2 minutes of people calling the vast majority of the time. When I talk about outreach, education, and assistance, that's basically what the benefits advisors do. We provide individual assistance to plan participants, employers, plan officials, service providers, either by way of giving information and education, either over the phone or how to find things on our website, or in certain circumstances, we can get involved to do informal dispute resolution for individual participant issues that they're experiencing. Excuse me. Our In 2019, we handled, as a nationwide office, over 166,000 inquiries. In addition to doing it over the phone, we also do web inquiries, and I'll tell you how to file a web inquiry with us in addition to our toll-free number a little later in the presentation. We recovered for participants over $510 million in benefits through informal dispute resolution. And as a result of benefits advisor referrals to our enforcement union, our enforcement unit, 501 investigations were opened. Our other unit, in addition to the benefits advisors, outreach, education, and assistance, is our enforcement unit, where they conduct civil and criminal investigations. They have national enforcement priorities and projects that we work on in different years. For the enforcement side, they recovered over $2.57 billion in direct monetary results in 2019. They closed 1,146 civil investigations, 275 criminal investigations, where 80 people had either guilty pleas or convictions, and 76 individuals were indicted. Short of the Department of Labor getting involved in a circumstance, before we come to the plan sponsor or the fiduciary, in certain circumstances that are outlined on our website, in like 17 or 18 different circumstances, it's possible, if the plan sponsor or the plan administrator has made a mistake, that we have something called a voluntary fiduciary correction program application that is available to people to apply to correct their own mistakes. But like I said, that has to be, you have to avail yourself of that prior to the Department of Labor getting involved in a certain circumstance. We had 1,600 applications with the VFCP program last year, and we had over 20,000 delinquent Form 5500s received, and I'll talk to you in a little bit about what a 5500 is in a little while. So ERISA, like I said, the Employee Retirement Income Security Act of 1974, has 4 titles. You'll notice in this slide that the Department of Labor only has jurisdiction over Title I, and we share that we share jurisdiction with other agencies for the other titles. So for instance, the IRS has jurisdiction over Title II. We share jurisdiction with them over Title III. And the Pension Benefit Guaranty Corporation, which is another federal organization, has jurisdiction over Title IV. But we have jurisdiction over Title I, which is the reporting to the government, which is the Form 5500 that I mentioned, and I'll talk about a little bit more later. We have jurisdiction over the disclosure requirements that plans must make to participants and beneficiaries, and with regards to fiduciaries. The Title I consists of 7 different parts that I'll just briefly go over. Part one is the reporting to the federal government, to the Department of Labor, and the disclosure requirements that plans have to give to participants. Part 2 is participation with regards to rules for employees or members to participate in a plan, and then vesting requirements for retirement plan purposes. Part 3 is funding with regards to plans, group health plans, retirement plans, other employee benefits that might be included in that. Part 4 is fiduciary responsibility, and we'll talk some today also about fiduciary responsibilities. Part 5 is the administration enforcement part. Part 6 is essentially COBRA, which is the opportunity to continue a group health plan after you've lost eligibility for it in certain circumstances for certain people. And then Part 7 is basically with regards to group health plans. The HIPAA provisions, the portability, et cetera, market reforms under the Affordable Care Act, et cetera. We have many laws that are under the umbrella of ERISA that we have jurisdiction over. They're not all listed here. Some of them are listed here. The first is COBRA. Like I said, that is the opportunity to continue group health plan coverage after a qualifying event has occurred or loss of eligibility for coverage. HIPAA, certain parts of HIPAA, other federal agencies have jurisdiction over certain parts of HIPAA, but we have jurisdiction over certain parts of HIPAA. We also have jurisdiction over the Newborns and Mothers Health Protection Act, which basically says the amount of time that a mother must be allowed to stay in the hospital after having a baby. We have jurisdiction over the Mental Health Parity Act and the act that amended it, the MAPIA, the Mental Health Parity and Addiction Equity Act. The Women's Health and Cancer Rights Act, which basically says that if a plan covers surgery as an option for breast cancer, a woman has a right to have restructuring of her breast to look alike after the treatment. Also the Affordable Care Act, we have jurisdiction over that. We have jurisdiction over the Pension Protection Act, and something that many of you have probably heard of, maybe all of you have heard of and perhaps been personally impacted by, also the Multi-Employer Reform Pension Act of 2017, where if there were certain retirement plans that might have solvency issues in the next 20 years or so, there might be different statuses assigned to them and certain actions that they must or can take to take care of that situation. And of course, the 21st Century Cures Act. So I'm going to talk briefly about what is an ERISA group health plan. So what plans do we have jurisdiction over? It would be employment-based or union plans that provide coverage for medical care like hospitalization, sickness, vision, dental, prescription drugs. Plans can provide benefits through what we call fully insured, where the plan sponsor pays premiums to an insurance carrier, or it can be self-insured. If it's self-insured, that means that the benefits are paid from the employer's assets or some kind of a separate trust set up by and funded by the employer to pay for the claims of the group health plan. There are arrangements that are not subject to Part 7, or where we don't have jurisdiction over them. Very small group health plans, basically under 2 people. Church plans, we don't have jurisdiction over churches. Government group health plans, that includes school teachers, local, municipal, county, state, federal. We don't have jurisdiction over our own plans. And then accepted benefits. One of the laws we have jurisdiction over, I'm sure you've all heard of, perhaps dealt with, perhaps had your life either enhanced by or plagued by or both, the Affordable Care Act market reforms. Different provisions that apply, whether or not a plan is grandfathered and how a plan will lose grandfathered status. Grandfathered basically meaning certain parts of the Affordable Care Act the plan would not have to comply with. And once they lose grandfathered status and are considered non-grandfathered, then they would have to comply with the Affordable Care Act. There's also the prohibition of pre-existing condition exclusions. Yay, that's a big issue for many, many Americans. That's one thing that your average person typically tends to know about and care about and be happy about. It also includes new provisions with regards to wellness programs. It issues a 90-day waiting period limitation before someone can be eligible for a group health plan. It established a prohibition on lifetime and annual dollar limits for certain plans. It issued a prohibition on rescissions, meaning that one could retroactively lose their coverage under a plan. Most of the time, there's a prohibition on that. There's exceptions for things like misrepresentation or fraud, but other than that, there's a prohibition on being rescinded from the plan retroactively. There's also new coverage for preventive health services that are mandated for plans. There was the extension of dependent coverage up to the age of 26 for dependent children, adult children. There's also a new requirement that in addition to the summary plan description, which we'll talk a little bit about later, there's a requirement for something called a summary of benefits and coverage and uniform glossary. And this is great for a couple reasons. One, the summary of benefits and coverage allows people, it has the content requirements are the same under every plan. So you're able to look, a person is able to look at what is covered as a summary at with one plan and other plans at the same time, and make an apples to apples comparison to determine which of their plan options they're going to choose. And the uniform glossary is wonderful because very often, this happens a lot in the law, but also specifically with regards to ERISA issues, very often what something means is not necessarily the common sense understanding of what something would mean. It is essentially a term of art, but the average person reading about that doesn't necessarily know that. And so the uniform glossary explains what things mean. An example would be people often get confused on what their maximum out of pocket means. And some people think, based on common sense, that once they have paid out of their pocket a certain, whatever that amount is, say $500 or $5,000 a year, once they've paid $500 or $5,000, that they have reached their maximum out of pocket, and the plan will therefore pay 100% after that. But what that really means for maximum out of pocket is typically that those amounts that are allowed and covered under the plan, and it doesn't include things like co-pays or co-insurance, etc. It also includes, the market reforms includes internal claims and appeals and an external review. So it modified the internal claims and appeals and added an external review. And the new and helpful part about this is that previously claims were handled by the plan administrator in a self-insured plan circumstance, or by the carrier in a fully insured circumstance, and they would make a decision about something, and the person would have 1 to perhaps 3 appeals available to them, and the insurance carrier or the plan administrator basically determined their own whether or not their own decision was accurate and would either uphold it or overturn it. Well, it's their own decision, so they have kind of an inbuilt bias towards upholding how they had handled something previously. But in certain circumstances, particularly those that require medical judgment, once someone has exhausted the internal appeals process, they have an opportunity to request an external review with an independent review organization, or sometimes a federal process or a state process. And there's also certain patient protection provisions that are available. One of the things, prior to the Affordable Care Act, wellness programs were available under HIPAA, but in addition to that, the Affordable Care Act made some changes to wellness programs. So basically, under the HIPAA non-discrimination requirements, plans may not require an individual to pay higher premiums or contribution rates than other similarly situated individuals based on a health factor. However, there are circumstances where that's not necessarily the case. If it is a wellness program that meets all of the requirements under the law for the wellness program, then sometimes they may have to pay a higher premium or have a surcharge or something like that. Okay, I talked a little bit about the summary of benefits of coverage and uniform glossary. Basically, we have a template that we provide that they have to adhere to. There's an exception of how to handle things that won't necessarily fit there, but basically it's limited to 4 double-sided pages with no smaller than 12-point font. It includes all statutorily required terms in the uniform glossary, as well as additional terms recommended by the NAIC, to where it's explained to people so they don't have to figure out what maximum out of pocket means, for instance. And it tells them exactly what that means, so that that's made available to people so they have opportunity to be educated about their plan and about their benefits and make decisions accordingly. The plans and issuers, and the issuer would be the plan administrator in a self-insured plan or a carrier in a fully insured plan, must make the uniform glossary available upon request within 7 business days. And anytime the Department of Labor or the Employee Benefit Security Administration says upon request, we always mean written request. Now, you're certainly always welcome to comply with an oral request or a verbal request, but then there are proof issues sometimes that are brought to bear if the plan administrator says they never received that request, and the other person said that they did. So we can only enforce a written request. The summary of benefits and coverage must include an internet address where the uniform glossary can be obtained. Time limits for deciding group health claims. Basically, it depends on the type of claim. If it's urgent, meaning they're going to risk like serious medical issues or perhaps death or something like that, then it's considered urgent. And there are time frames that adhere to that. Urgent is not, I have surgery scheduled next week, so I need to get this pre-authorization before the surgery. It has to be based on it being medically significant, where something bad might happen to them medically if they don't receive those services, rendering that they need to get a decision right away, basically, or within that time frame on the slide. Pre-service would basically be like a pre-authorization situation. And it would be obviously before they get the service that's provided or a claim. One thing that it's very important for everyone to know, whether you're a plan administrator or a participant in a plan, is that a pre-authorization does not mean that they are going to pay for the claim once they get it. The way that I explain it to people is basically a pre-authorization means at first blush, with the information they've been given that's limited, they don't see a reason that they're not going to cover it. But so sometimes it's called pre-approval. So people think, I got pre-approval. Basically, you're telling me if I incur this service, that you're going to pay my claim for it. And I'm here to tell you that that's not necessarily the case, and people need to be aware of that. And so what I like to tell people is, don't rely on a pre-authorization because of what I just told you. What you need to know is it a covered service? And even if it is a covered service, it may be the case that they only approve and pay for that covered service less than 0.5% of the time. So then you need to find out what is the criteria necessary for approval and payment of the claim, and then compare your situation to the criteria necessary. And if you meet it and you can justify that medically, then they should approve and pay the claim. And if you don't, then that tells you whether or not you should get that service. Or if you want the insurance, you may want to get it regardless of whether they pay for it, but whether or not the insurance carrier is going to pay for it. And then post-service, you incur the claim, and then there's time frames for them to do the initial claim and then an appeal for them to deal with that. There's a 15-day extension available automatically to them. They need to the plan administrator to make a determination on the claim. And then if they need an additional 15-day extension, they can get that as well. They need to let you know that in writing if they do that. Okay, the external review. Basically, I mentioned already that this is a situation where if you've gone through the internal review process and the claim is still denied, then if it's a situation involving medical judgment, you can ask the plan administrator or the carrier to have it sent out for external review. And this slide basically talks about it's either an independent review organization or a federal Health and Human Services administered process, or some states have a state process that you can avail yourself of. Okay, I'm going to talk briefly about the Mental Health Parity Act and the Mental Health Parity and Addiction Equity Act of 2008 and the 21st Century Cures Act. Basically, mental health parity only applies to plans that offer both medical surgical benefits as well as mental health and or substance use disorder benefits. You have to look at all possible combinations of medical surgical and mental health substance use disorder benefits. And basically, to be in parity, if they offer mental health and or substance use disorder benefits, they have to offer those in parity with medical or surgical benefits. In other words, they can't be more generous in their medical surgical benefits than they are with their mental health or substance use disorder benefits. And there's like 6 different ways that this is analyzed and looked at to determine if that's the case. However, one thing to know about the mental health parity is that there are a lot of plans that it does not apply to. It does not apply to employers with 50 or fewer employees, but if it's a non-grandfathered plan, meaning it's lost grandfathered status under the Affordable Care Act, which I mentioned before, then small group market coverage must include coverage for mental health substance use disorder benefits for plan years beginning on or after January 1st, 2014. Now, keep in mind, this is not, there's a whole lot of plans that are not included in this. So, such as self-insured plans, large plans, etc. Also, if the plans can show that the increased cost by offering the mental health or substance use benefits is prohibitive or burdensome for them, they can apply to get an increased cost exemption from having to offer mental health or substance use disorder benefits. Okay, so earlier I mentioned that part of Title I of ERISA, it includes disclosure requirements. Part 7, as I mentioned before, it applies to group health plans. There's lots of disclosure requirements. I'm only going to go over a few of them here. There is a required disclosure for grandfathered plans. Plans must put in their summary plan description or otherwise whether or not they are a grandfathered plan or a non-grandfathered plan under the Affordable Care Act. If in the disclosure for the non-grandfathered plans, there are certain information that must be included for internal claims and appeals, information regarding the external review opportunities available, the opportunity to designate a primary care provider and what the options are with regards to doing that. Matt, it's not letting me forward the slide. Let's see if this might help. There we go. Okay, other disclosures that are automatic that must be provided to participants is the summary annual report. The COBRA notices when someone is a qualified beneficiary that has had a COBRA qualifying event, they must be issued a COBRA notice. HIPAA notices, there are certain HIPAA notices that are required to be sent out. And then notices and disclosures in connection with claims for benefits, such as you're probably all familiar with the explanation of benefits. And there's certain requirements that must be on the explanation of benefits, such as if it's denied, a reason for the denial, etc. Now I'm going to talk just a little bit about COBRA, which, like I've said, I think at least twice now, COBRA continuation coverage is basically the opportunity to continue coverage for qualified beneficiaries, which would be the employee, a spouse, or their dependents, if they've had a qualifying event that causes them to lose eligibility for coverage. It gives them the opportunity to continue the coverage after it's lost due to losing eligibility. Examples of qualifying events would be termination for the employee. And termination, we don't mean being fired, we mean job loss. So it could be a voluntary loss of employment, or a reduction of hours of employment that results in lack of eligibility for the group health plan. And then examples of COBRA qualifying events for beneficiaries, which would be the spouse and the dependent children, would be divorce, death of the covered employee, etc. Who is entitled to COBRA? To be entitled to COBRA, 3 basic requirements are met. It has to, your group health plan is subject to COBRA, and I'll talk about that here in a second. A qualifying event occurs, such as I just mentioned, the termination of employment, reduction in hours, death of the employee, divorce, etc. And they have to be a qualified beneficiary. Plan subject to COBRA. Is your health plan subject to COBRA? Yes, if it is a group health plan sponsored by a private sector employer or union that employed at least 20 full-time employees or the equivalent of part-time employees added up in the previous calendar year. Okay, so that was just a brief touch on COBRA. Now we're going to talk about fiduciary duties for group health plans and retirement plans. Basic information about retirement plans. There's basically 3 different kinds. IRA-based plans, simple IRA, individual retirement account. This would not be the individual retirement account that you would set up at your bank. This would be sponsored by the employer or by the union. And the benefit is the accumulated contributions that are put into the account plus the earnings that those contributions are making. And that's the same with regards to defined contribution plans. A defined contribution plan would be the benefit is the accumulated contributions of either the employer or the employee or both. Plus the earnings. And this would be an example of a defined contribution plan would be like a 401k plan. Defined benefit plans are the traditional pension plans we think of where the benefit is a specified amount. So once you retire, you are eligible typically to a monthly benefit for your life, sometimes your spouse's life or minor children for a certain period of time. Occasionally, there are lump sum options that people can get, but that's not necessarily always an option. It depends on the plan rules. Unless plans are statutorily required to offer or do certain things, it's basically anything beyond that is up to the discretion of the plan and would be handled in accordance with the plan rules. What are the elements of a plan subject to ERISA? Well, ERISA and the code is referring to the IRS code. Plans must be maintained pursuant to written instruments. They have to be in writing. Those instruments have to describe the benefit structure and the operation, the rules of eligibility, etc. It also requires that the written instruments provide for one or more named fiduciaries, at least one person who is responsible for the operation and administration of the plan. And by named fiduciaries, we don't necessarily mean a person's name. In fact, we recommend that it be more of a position title, and whoever's in that position would be the named fiduciary as opposed to a certain person's name, because of course that changes over time. What is an ERISA fiduciary? As I describe this, one thing that I want to point out and make abundantly clear is that a fiduciary is one of the very highest standards of conduct that one is held to under the law. And there can be very strict requirements and very serious consequences for not maintaining fiduciary duties. And we have presentations available about fiduciary duties for retirement plans and group health plans, etc. And like I said, I'd be happy to share those with this organization or other organizations. But basically, a fiduciary is any person who exercises discretionary authority or control over plan assets or administration, or gives investment advice for a fee. So basically, someone who exercises discretionary authority or control over plan assets. ERISA has a functional definition. It's not dependent on a job title or documents. It's whether or not someone does what I just described. If they do that, if they exercise discretionary authority or control over plan assets or administration, or give investment advice for a fee, then they would be a plan fiduciary. Basic fiduciary duties under ERISA: to act solely in the interests of the participants and their beneficiaries, to be prudent, and prudence is a process. What I always recommend to people is, usually we're looking at a situation in hindsight that did not go well. Just because it didn't go well doesn't mean that the plan wasn't handled prudently. But you don't know if something is going to go well or not. You can only try to be as prudent as you can be. One way to take care of yourself in this situation, to show prudence, is to make and keep good records of how your process is prudent, what you took into consideration, the different things that you looked at, why it is that you think this is a prudent decision or course of handling something prior to actually taking care of it, or during the course of taking care of it. Another fiduciary duty: to pay only reasonable and necessary expenses of the plan, to follow the terms of the plan, to hold plan assets in trust or with licensed insurance company. Now, in terms of only reasonable and necessary expenses of the plan, I have to tell you, and I've seen this with regards to some union plans, so I think this would be helpful to know for union plan officials. How do I say this delicately? I work with what I consider to be very frugal people who have very conservative ideas about what would be considered reasonable and necessary. So if there is any question, or if you think something is maybe a little bit generous or a little or too generous or might be questioned, then you might want to document or try to justify in advance, while it's fresh in your mind and the situation is going on, how it is that you think it's a reasonable and necessary expense as some kind of potential defense if we're ever auditing or investigating your plan and how things were done. One of the things that I make a big deal out of is know who is responsible for various activities required by the plan. Who has custody of the plan assets? And I'll talk about this for just a few minutes. The record keeping, the benefit decisions, the directing investments. A couple of things here. One, our country, as we all know, is in the middle of a pandemic. There are all kinds of layoffs, all kinds of job movement, people changing positions, maybe restructuring, maybe combining positions. So it's extremely important to know, within the purview of what I'm talking about and probably other things as well, who does what with regards to the employee or union sponsored benefit plans. Whether or not you hire a third-party administrator to do it, what's done in-house, who does what. When someone leaves a job, either permanently or temporarily, what fiduciary duties or other duties do they have related to employee benefit plans that need to be maintained while they're gone? What kind of training, if you know in advance, may need to happen for other people while they're gone? At least one person has to know, preferably more than one or several, depending on how big the employer or union is, and how many employee benefit plans there are, with regards to who all does what. So-and-so does this and is in charge of this plan responsibility. So-and-so does this, so-and-so does this. Someone leaves for maternity leave. What is she responsible for? Or he? What are they responsible for? And who's going to take care of that in their absence and make sure that it's done timely and properly? What if they leave unexpectedly? Is there someone else that's trained and capable and ready to take over that to make sure that things are still handled in a timely fashion? Record keeping actually has a couple different meanings here. Of course, there's your regular typical record keeping, but then there's record keeping with regards to what is often, but not always, hired out to a third-party administrator in terms of keeping the records of people who are eligible for plans. Sometimes for many, many, many years after they no longer work there, 50 years, 60 years. For instance, if they worked 50 or 60 years ago and are now going to be eligible for a pension benefit, where are those records that long ago are probably paper unless they have all been transferred onto a computer? One thing that's always very important when you have a third-party administrator is that your contract indicate that the employer or the union retains ownership of the records related to the employee benefit plan. Now, the record keeper might have some ownership too, meaning they want to keep a copy for themselves. But if they're no longer going to be your record keeper and you've hired someone else to do it, or you decided to do it in-house, make sure that the contract says that you own those records so that they're required to turn them over to you so that you have the records necessary to maintain people's benefits currently or in the future. Who's responsible for making benefit decisions, and with regards to directing investments. This is probably the most important slide of the entire presentation, so this will take me a few minutes. Tips for avoiding common problems. Carefully select and monitor service providers. You don't necessarily have to get the cheapest one, but you want to get the prudent one. You don't want to get the most expensive one necessarily either if that's not prudent to do so. But I recommend that you have a thought out process that you keep records of and document how you have carefully selected and monitored your service provider. And when it's time to renew their contract, don't just renew their contract, but carefully consider whether or not it is prudent to keep that person. Do you compare, or that provider, do you compare that provider to another provider at the time of renewal to make sure they're still the best provider for you? Make required disclosures to participants and beneficiaries. Understand your plan and your responsibilities. Often we'll call up an employer, because we typically call the employer rather than the third-party administrator or the carrier, even though we might call the other people, but typically we try to work with the employer, and they'll often say, we don't know what the plan covers, we don't know lots of things, because we hire that out and that's someone else's responsibility and job. No, someone with the union or someone with the employer, and maybe many people, needs to understand the plan and the sponsor and administrator responsibilities under the plan. Make timely contributions and monitor plan assets. Timely contributions is one of the things we take most seriously when we get calls and complaints from people about untimely contributions. Monitor plan assets to try to make sure they are being handled in a current manner, which I'll talk about here in a few minutes, and make sure there's no dishonesty and embezzling and that kind of thing. So have some cross checks and balances in place to monitor the plan assets. And you also have a requirement to, like I said before, monitor your service providers. So you have to understand what it is that they're doing for you and what they're supposed to be doing to make sure that they're doing that properly. And then file reports with the government, the 5500s that we'll talk about here in a minute, and keep good records. That is your best protection from an investigation or an audit is good records. Explain what you did, why it's prudent, etc., and hold on to those records. Delegations. When assigning responsibility, whether to an internal committee, human resources department, or an external service provider, make sure they understand their responsibilities. It's helpful if they understand each other's responsibilities as applicable. Make sure at least one person understands everybody's responsibilities so that nothing falls through the cracks as things occur. Make sure they have the knowledge and information necessary to carry out their responsibilities. Monitor to make sure they carry out their assignments. Oh, I'm sorry, I've already talked about this a little bit. Record keepers, if you hire a third party to maintain your records, remember, make clear in the contract who owns the records. You can't avoid the duty to maintain records by contract, delegation, or otherwise. You're still on the hook even if you hire it out, and monitor their work. I'm going to talk briefly about what is the summary plan description. It's the SPD, the basic ERISA disclosure document, telling people this is what the plan consists of. This is the organization and structure of the benefit, the rules of eligibility, the requirements, what's covered, etc. Must be a complete and accurate summary of the plan, including the benefits, rights, and obligations under the plan. Must be written to be understood by the average plan participant. Some of the required disclosures to participants and beneficiaries. The SPD, a summary of material changes, the summary annual report, pension benefit statements, letting them know either what their current accrued benefit is or maybe on a 401k what their current balance is. Plan documents, the summary plan description is a summary of the plan document. Pension benefit statements, they are provided automatically to participants. If it's a situation where the participant gets to direct the investments in a defined contribution plan, then those must be provided to the participants quarterly. In defined contribution plans where the participants do not direct the investments, then annually. And for defined benefit plans, those traditional pension benefits I mentioned earlier, every third year. If people aren't going to be available or able to get loans or make changes to their investments or get a distribution for a period of time, it's called a blackout period. A notice of the blackout period has to be given to the participants. There are content and timing requirements, and usually there's a minimum of a 30-day advance notice requirement, maximum of 60 days to all affected participants and beneficiaries. The defined benefit plans have to provide an annual funding notice. There are content and timing requirements. Usually this must be provided no later than 120 days after the close of each plan year. The notice must include, among other things, the plan's funding percentage. I'm going to talk just a second here on a couple of slides about fee and investment disclosures. It's a disclosure requirement only for participant-directed plans. That would only be for defined contribution plans, not the traditional defined benefit plans we talked about. And we have on our website a field assistance bulletin, which gives information about what must be included in that. But what information must be disclosed? Plan-related information, general plan information, administrative expense information, and expenses that are allocated to an individual must be included. Also, some disclosures must be provided on request. And of course, request means written request. The plan document, the current summary plan description, insurance contracts, other instruments under which the plan is established or operated, the Form 5500 or the short Form 5500, which is the disclosure requirement that's required annually to be filed for most plans with the Department of Labor and with the IRS. And then there's miscellaneous disclosures. How to furnish documents. You can do it in hand delivery at the workplace. If you do that, make sure you get a signature or keep track of proof that things were provided and to whom. You can do it by mail at their last known address that they provided to you. Electronic delivery, but the one thing I want to say about this is subject to certain regulatory standards. It can only be done in a certain way. You can't just say I sent you an email or I'm providing it on the website. And they have to have certain electronic delivery available to them as an employee for that to be available and used. And they don't have to consent to that. So they can say, I want it to be delivered by mail or in writing, printed out. And so they do have the right to not provide consent or withdraw consent for that. Posting in a common area is a good thing to do, but it's not enough. It doesn't count as disclosure. Maybe the most important thing that I have to talk about, the thing that we take one of the most serious, if not the most serious, is if a participant contribution is deposited into a plan late. This rule is very important, and the exact wording is very important, and that it be adhered to strictly is very important. Participant contributions become plan assets as soon as reasonably segregable from the employer's general assets. Never more than 90 days, but they must be either put in trust promptly or sent to an insurance company if it's a group health plan. If it's a retirement plan, then they need to be sent to the retirement plan. Employer contributions, you must contribute or pay premiums per the plan documents, either at the same time as it comes out of pay or sometimes at the end of the year when the employer does taxes. Okay, so this is the rule. Amounts withheld from employees' wages must be transmitted to the plan as soon as they can reasonably be segregated from the company's general assets. A small plan will be deemed to be in compliance if the participant contributions are received by the plan within 7 business days. This is a safe harbor. We typically think that big employers can do it even quicker than that. We do offer the voluntary fiduciary correction program that I talked about earlier. There's certain circumstances where you can do it. You can look on our website to see if you experience a mistake or a situation, to see if that is covered by an opportunity to apply for the voluntary fiduciary correction program. Keep in mind, you have to contact us first about the issue before we contact you about the issue. And then the last thing is, as I said before, you can place inquiries with our office, either on the phone with the toll-free line, which is the second bullet point there. You can also file a web inquiry, and that's the first bullet point there that you would go to do that. And then a couple of helpful phone numbers that you might find valuable in certain circumstances. And then our website, which has changed in the last couple of years from what it used to be. And that's basically all that I have. I want to thank you for your time and your presumed attention. And I realize that this is not the most scintillating material talking about the Employee Benefit Security Administration or ERISA and related laws. But I am passionate about the information and about conveying the information to help people be in compliance and have their rights met and satisfied. And so thank you very much for allowing me this opportunity. And I would be more than happy to entertain questions at this time.